The side's ready. Yes. Appellant may proceed. Also, just a general announcement. You let me know how much time you want for rebuttal. I'll try to remind you, but it's ultimately going to be your responsibility because you have the clock in front of you.
Okay. I'd like to reserve 5 minutes for rebuttal. If it may please the Court, my name is Hal Sandridge, and I represent Jackson National Life Insurance Company. We are here on an appeal of a summary judgment in which the trial court found that Jackson National did not give the plaintiff notice of a non-renewal of an insurance policy, and that by doing so, we breached the policy. In our appeal brief, we argue that there was no contractual, common law, or statutory duty to give the notice to the plaintiff in this case. In response, Lovallo has argued that that issue is not really the issue and that there's an alternate issue upon which the opinion from the trial court can be affirmed. So it's our position that by not responding to that issue, they have conceded that there is no contractual, statutory, or common law duty to give notice of non-renewal. With respect to the issue that they did raise, they have argued for the first time that Jackson National is stopped from contesting insurance coverage in this case because the plaintiff relied upon the fact that there was an automatic debit from her bank account and assumed that because of that, coverage would continue. There's obviously several defects in that argument, all of which we have pointed out in the reply brief. The first and most important is that the plaintiff never raised this theory at all. In the trial court, in arguments, in the pleadings, the entire case was premised on a breach of an agreement for failing to provide this renewal notice. Why that is important here?
Why is that important here? Because can't we affirm on the tipsy coachman?
No, not on this issue. There are several reasons. Number one, because this was not pled, discovery was not taken on this issue. And it would be a denial of our rights to ask questions and gather evidence to defend against such a claim. For instance, Mrs. Lovallo now claims in her brief, remember, there was an affidavit filed up by her, but she never raised this issue in her affidavit, again, because it had not been pled. But we would have deposed her and asked her specific questions, such as, who told you that simply because there was an automatic renewal provision, that meant the policy was renewed automatically? What basis do you have in the policy? What acts of Jackson National led you to believe that this was in fact the case? So we were deprived the opportunity to take discovery on an estoppel issue. Estoppel is typically a fact-intensive inquiry and is generally unsuitable for summary judgment. So we believe that on that theory, this record is undeveloped and cannot be affirmed on that alternate basis.
Well, speaking of estoppel, I understand there were some conversations between Mr. Lovallo and the insurance company.
Yes.
And is it true that he proposed reducing the amount of insurance coverage?
Yes.
And the company's response was what?
You cannot do so.
Because?
Because of the irrevocable beneficiary's rights under the policy.
Because of her rights?
Mm-hmm. Her rights under the policy. So the question is, what are her rights under the policy? Her rights were given by the MSA.
So the insurance company took the position they could make no change to the policy without her agreement.
That's an important distinction. Yes, Your Honor, that's true. Change. In fact, they put that exact language in a letter to Mrs. Lovallo and said, to Mr. Lovallo, that says we can't make any changes under the policy. So they couldn't change the beneficiary. They couldn't change the amount. All they could do was comply with the terms of the policy. And nobody has pointed to anything that they did that was not in compliance with the policy. They did not change the policy in any way.
Mr. Lovallo couldn't lower the policy $1, but by failing to make the premiums, he can totally wipe out Mrs. Lovallo's interest.
Well, failing to make a premium payment is different than failing or refusing or deciding not to renew a term policy. If what had happened is that there was a call by Mr. Lovallo 1 year into this 10-year term, and he said, I'm not going to do this anymore, I think that at that point there might have been a problem because the MSA said that she had rights under the policy. But what the policy provided is a 10-year term. And so the non-renewal of that is a term in the policy. This is what they bargained for. I say they. I don't know whether Mrs. Lovallo was in on the original decision to get this policy.
Well, what is the language in the decree? That's what made the insurance company refuse. That's why they didn't agree to the coming down on the amount, right?
Yes, yes. It said that she was an irrevocable beneficiary, and that they had to keep the insurance in force. I think the language is intact. 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 And they did. They never, ever canceled the policy. Until it went to zero. Well, you say it went to zero. It expired. And that's a decision that insureds always get to make.
Is there a difference between expired and intact?
I don't think so. I don't think so. I think that it remained intact until it expired by its terms.
So you think the policy was intact even though it had expired?
It remained intact until it expired by its terms, yes. Yes. That's a choice that insureds always have to make. I'm sure you're familiar with the concept of term policies and that you get very inexpensive premiums during the term. And then if you decide to renew the policy, the premiums typically are dramatically increased. And I'm sure you can imagine the underwriting reasons for that. It's usually age. And so whenever, take Mr. and Mrs. Lovallo out of this equation, an individual has to decide whether or not to renew a policy. That is basically a new decision that they're making. So, yes, the insurance company did everything it was supposed to do under the terms of this policy, and it kept it intact.
So the insurance company is aware of the divorce decree.
Yes, they were.
And clearly the idea of the divorce decree is to protect Mrs. Lovallo.
Yes.
Doesn't that create some kind of duty on the part of the insurance company?
No. I think it creates a duty for them to comply with the terms, and the terms said that Mrs. Lovallo was an irrevocable beneficiary, which she was. And the other obligation that the insurance company had was to comply with the terms of the policy. The terms of the policy did not require anybody to get notice of the renewal, assuming that that issue is still in this case. I would emphasize I think they've abandoned that issue. It sounds
like you're conceding that she had the equitable ownership that she asserts.
I do agree that she would have the equitable ownership. I disagree with their belief that that entitles her to receive notice of the non-renewal of the policy. That only would go to the legal owner if that's what the policy required. And our whole point is that there is no such requirement. Assume that she has some sort of equitable ownership. Even the owner had no right to receive renewal. Life insurance.
Did the owner listed on the policy receive notice of the right to renew in this case?
No.
It wasn't sent to either the
husband
ex-husband or the wife?
No. The husband apparently called up and said, I don't want to renew, and stop debiting. And then they sent the letters that said, you know, you've decided not to renew. We urge you to do so, but, you know, if you don't, then there's going to be a lapse.
Did that go to the appellant as well as to the ex-husband?
That went just to the owner of the policy, the husband.
Just to the owner?
Yes, absolutely.
Well, earlier you had said that it couldn't be changed, nothing could be changed without the irrevocable beneficiary, who is the appellant here, and yet in this case you took his word for it without giving her notice of it, did you?
Well, keep in mind, we're I think quibbling about what the word change means. In our opinion, a non-renewal is not a change of the policy. Our belief is that we complied with the policy because the
If we disagree with you and find that that was a change, do you lose this case?
No, because for several reasons. Number one, we weren't required to give notice. That was the obligation of, if she wants to take the advantages of being an owner, then she has to take the detriment. It was her responsibility to renew. We didn't have to give her notice of it. She didn't do it. Number two, she contends that she would...
What detriment, you said she had to take the detriment of it. What detriment did she not take? She was getting money deducted from her account, was she not? So what detriment did she not take?
Not at the time of the non-renewal.
Earlier, though.
Earlier, yes.
So what detriment did this woman not take?
Well,
you made a statement she didn't take refused to take the detriment.
Sure, the owner has certain legal obligations under the policy, just like the insurance company has obligations under the policy, so does the owner. She, as, let's call her an equitable owner, had none of those obligations under the policy. So my point is, like, for instance, the payments under the policy, the renewal of the policy, she had none of those obligations on her. So if she's saying, I want the benefits of it, then she has to take those obligations. And one of the obligations is to renew, which she didn't do. But here's...
She didn't get notice of it. So she's the owner. I can understand you saying she didn't follow through, she got notice. But her claim here is that she did not get notice.
I understand that. And so this takes us back.
I just want to let you know.
Okay. This takes us back to our first issue that is the primary issue. Is there a contractual, statutory, or common law basis? And the plaintiff has been unable to show any of those things, which means she's not entitled to notice. I'll save the rest of my time for rebuttal.
May it please the Court. My name is Tom Staples, opposing counsel, of course. Your Honor.
Why don't you start where she left off? What is the contractual language you are relying on?
Judge, there's a statement in the ownership section of the policy itself, and I'll quote it. It says, owner of the policy, while the insured is living, all rights of this policy belong to the owner may exercise these rights subject to the interest of any assignee or irrevocable beneficiary. And that certainly puts Jackson National on notice of at least that statement. They were put on notice, certainly in this case, by the
What is the statutory language that confers a right to notice that the policy is expiring and should be renewed?
Judge, I don't believe there is statutory language.
Is there language in a statute that requires that such notice be given for life insurance policies?
There is, but not particularly for life insurance policies, no, sir. Other forms of insurance, yes.
So the fact that the statute's required for other forms of insurance suggests, under the canons of statutory construction, that there's intentionally no requirement here, that there is no obligation on an insurance company to give such notice.
Judge, I don't know if I agree with that. It may just be that it was overlooked by the legislature. I just don't know.
All right, so if you're not relying on a contract, you're not relying on a statute, I assume you're going to tell us about some common law cases.
Yes, sir.
Which are they?
Might I do that? Yes, sir.
By
yes,
all
sir.
means.
We believe that we were entitled to notice, Ms. Lovallo was entitled to notice, because of an amalgam of things in this case. One was the quote that I just read. Another one was that the Doxy case that the Court is familiar with made her the equitable owner of this policy. It seemed to me that that line of cases was intended to protect children of divorce and divorcees. Otherwise, they have no protection, just like in this case. And certainly Ms. Lovallo was in that regard. This was a divorce case. And more importantly, there was a course of dealing that was set up here. And if I might begin that conversation with the letter that Ms. Lovallo sent on May the 15th of 2003.
I'm sorry, tell me about this case that you're relying on.
In the course of dealing, Your Honor, we're dealing with relying on Lewis State Bank versus Travelers, which this Court decided, and also some supplemental authority that we handed into the Court, the Ricker agents.
What happened in that case?
In the Lewis State Bank case, Your Honor, the Court here did decide or did not recognize that in that particular case it recognized and applied the general rule that an insurer's conduct can create a duty to notify an assignee of a life insurance policy that premiums are due under an existing policy. and an assignee's status is clearly at least equivalent to that of an owner or irrevocable beneficiary. And then the Ricker case versus Hoxie went on to state in a concurring opinion, Justice Orfinger mentioned that a course of conduct between the parties can give rise to a reasonable belief that there exists an agreement that renewal notices will be sent, and we think that was the case here.
All right, so are you saying that over this 10-year period, every year they sent out notices of a need to renew?
No, sir. Yes, sir, they did. I think that evidence is not in this case, so I can't make that statement. I can make this statement, that for 10 years they deducted automatic drafts out of a joint account as it started out in 1994. And when the divorce took place, about December of 2002, it became an account just in Ms. Lovallo's name, and they continued to draft that account until this policy expired, probably in late July or late June of 2004. Mrs.
You're just talking about automatic electronic funds transfer?
Yes, sir. Every month, and it was done on a monthly basis, not on a quarterly basis.
All right, so how is that course of dealing different than if the policyholder had written a check every month?
Judge, in this respect, Ms. Lovallo wrote a letter on May the 15th of 2003, some 12 or 13 months before this insurance policy expired. And it's really during that last 12 or 13 months that we hone in on most of our course of dealing, and it's this. It was two prongs. In her letter, and her letter is loaded with information, she indicates in there, she sends a copy of the divorce decree to Jackson National with the marital settlement agreement. She indicates in there that she is the policy owner and the beneficiary cannot be changed, and she was right on point because of the Dixon case.
Didn't the insurance company respond to that letter, though?
Yes, sir, they did.
And what was in that response?
Not much, Your Honor. Basically, their response was more of a non-response, other than the fact that they said that we got your letter. They said that we don't recognize you as the owner, and they included a change of owner form, which I would argue is irrelevant in light of the...
How did their course of conduct? It seems to me that if they send out a letter saying you are not the owner of the policy, if you become an owner, you need to execute this form. That seems to be their course of conduct saying, whoa, you wanted something more from us? You need to do something else.
And Your Honor, my argument would be I'm not sure she had to, because in her deposition she stated, and which is in the record, she stated that she and her husband talked about that issue. He was the agent for this policy, by the way. He used to work for Jackson National, and they decided that was not necessary because of the circumstances. Now, in their letter...
Was he acting as an agent at Jackson National? Wasn't he canceled as an agent at some point?
Back in several years prior to that, about 6 or 8 years prior, he got very ill and had to leave all of that.
Well, how could he bind the insurance company if he had been canceled as an agent 8 years before?
And, Judge, I'm not arguing that. But what...
Well, you said the two of them decided, and somehow you want the two of them making a decision to somehow bind the insurance company. I thought that's what your argument was.
No, sir, that's not my argument. My argument is this, that in that letter back to Mrs. Lovallo, the insurance company failed to respond to the most important parts of her letter of May the 15th. She said in there, I have paid, not we have paid. She said, I have paid and continue to pay for this coverage until he is 70. That meant that draft that they were taking out was coming out of just her account. And it also meant that she intended and had a reasonable belief that she would be able to pay for this policy until this man reached 70, which he never did. And coincidentally, during that time period fell the renewal of this policy after 10 years, and that occurred on May the 23rd of 2004. She didn't know that. So in her last paragraph in her letter, she committed the insurance company to respond, and they didn't, and she did that by this language. Please confirm receipt of this information, which they did. And she says, if there is a reason to challenge or debate this information/issue, please inform me of such immediately. And for 12 or 13 months, and in that letter that they sent back, they never did. Each month they continued not to respond, and a reasonable belief arose in her mind that she had this insurance coverage was still in full force and effect. Now, coupled with that, was a second prong, and that is that during that 12 or 13 months between her letter and when the policy expired, they continued each month also to take premiums out of her account by debit. And that was continued right on up until the time that Mr. Lovallo made his phone call to him, and they canceled it. She was never sent notice. We think there was a course of dealing there that led her to have a reasonable belief that she had insurance coverage here on her ex-husband's life, and in fact, that was wrong. She had nothing.
But she did have it until he canceled it.
Yes, sir. And we just feel that...
refused to renew until he refused to renew.
Yes, sir. And we
he
just
told them, right, he said, after this 10-year period, the premium jumps up so high, we're not going to do it.
Yes, sir. He had called and said something to the effect that, well, the premium went from $134 up to $1,012. And Ms. Lovallo had indicated in her deposition, these people had done elder law estate planning is what they'd done here. And Mrs. Lovallo stated that Mr. Lovallo, she didn't expect would live more than a year. So, I mean, she knew that this man was going to pass away very shortly, and she would therefore have kept this policy in effect as she stated in her deposition. But she never got notice, and that never happened. So our argument is an amalgam of things, and that is specifically that under the Dixon case, she is the equitable owner and should have received notice, and also on the course of dealing that I've just described under the circumstances of this case, they owed her a duty to give her notice.
I think you're okay on she's the equitable owner, but where does the duty to give notice come from?
Your Honor, that would be strictly from the Lewis State Bank and Travelers case, and maybe an extension of the Doxy rule, that would be the case. Otherwise, there's no protection for somebody like Ms. Lovallo in a situation like this.
There may not be.
Yes, sir.
But, I mean, there's a statute that says if it's automobile liability insurance, they've got to give notice.
Yes, sir.
But there is no such statute for life insurance.
That's correct.
So aren't you asking us to conjure up a requirement that doesn't exist?
No, sir, not at all. I'm saying that under the circumstances of this case, particularly with the Doxy case, with the Dixon case, and also with the course of dealing that we've cited under Lewis State Bank.
But now you talk about that is she authorized those transfers, and they took place.
Initially, I would assume that both of them had to authorize the transfers out of a joint account back in 1994. About the time of the divorce, it became an account just in her name. And it was her account at that point. And what Jackson did is they stopped drafting her account without her knowledge.
They can't draft her account. She draws on that account. And the bank is the drawee, and they are the payee.
Yes, sir.
And the fact that she paid by that means instead of by sitting down and writing a check every month doesn't strengthen her position as far as this notice question is concerned.
Well, Judge, my only argument would be that certainly that was something that, Jackson had control over, that they stopped drafting that account, and she didn't know anything about it until she applied for the insurance after Mr. Lovallo's death and found out that no payments had been made out of her account.
Well, on what authority would they have asked anybody for any money if they were told by the record owner of the policy, we're not renewing?
Your Honor, we would argue...
They probably would have been guilty of theft or something.
Well, we would argue that he was not the owner of the policy at the point that he called this insurance company. Ms. Lovallo was the owner of this policy at that point. It had been assigned to her, and under the...
But the insurance company had taken the position before then that if you want to change the owner, you have to let us know and sign this form.
Yes, sir. And again, I would argue that I don't think that was necessary under the fact situation of this case.
Well, Counsel, let me ask you this. Was Mr. Lovallo entitled to receive notice of renewal?
Yes, sir.
As the owner, as the facial owner?
Yes, sir. Now, I think the
Under
argument...
what theory, where does that duty come from?
he in fact did receive 2 notices.
But I know, but that could have been a gratuitous advertisement too. Was he entitled, as the owner, was there a legal duty on the part of Jackson to send the facial owner notice of renewal?
Well, they indicate that that was not the case. They indicate that in the policy it had that information printed in the policy of when the 10 years would be up and what the step up in premium would be. He was the one that had the policy. Mr. Lovallo did not
You're not
have.
answering the question.
Yes.
Forget about what they contend. On what basis do you claim that he was entitled to notice? I know they gave notice, but on what legal basis were they required to give notice? To Mr. Lovallo, or to the owner?
There was no statutory reason or contractual reason for that, Your Honor. And they
So
say
it was
that,
an advertisement. Hey, here it is, your policy's gone, we want you to renew. You have the right to do it, to the owner, the facial owner. But you say there was no obligation to even give that, no
well,
duty.
they say there wasn't, but they did in fact do that.
I understand, they
And
did it,
Their
but
course of
the
business.
insurance companies are always sending out circulars ad nauseum trying to get you to renew, but do they have to is what we're trying to boil this thing down to. And Mr. Lovallo is the facial owner, and it seems to me that there's got to be some kind of legal duty there to him before you can say the equitable owner is entitled to the notice.
Yes, sir. I
That's
see
my
what-
train of thought.
Yes, sir. I understand.
And I'd like for you to address that as best you can.
Well, Judge, and the only thing I can say there is that, I think it's implicit in being an owner that you have to receive notice of these type things. And in fact, that's their course of business, that they do send notice out. They may say they don't have to, but they do. And I would suggest they do that in every occasion. And it's not necessarily circulars and advertisements. It's saying, we want your business again. Here's the new premium. Pay it, or it's going to lapse.
But there's no statute on it, as Judge Benton has asked you, and there's nothing in the policy that says at the end of this term, we will send you notice that you'll have a right to renew for additional period of time at an additional premium.
That's my understanding.
Okay.
Yes, sir.
That answers my question.
Thank you. Your time is run.
Yeah. Yes, sir. Thank you.
Well, I'd like to start with you right where I left off.
Yes, Your Honor.
Was there a legal duty to tell Mr. Lovallo about this renewal
No,
procedure?
there was not. And
Not
I'd like,
common law, not
there's no statutory, common law,
contractual or
contractual
or
or otherwise. And I
What
would like,
was the reason for the notice? Was it somewhere akin to an advertisement,
You
like
know,
I'm speaking of?
that is exactly what it is. And I want to clarify, there was never a notice of non-renewal. It is the obligation for you to renew if you want to renew when the term is expired.
That's a
All-
non-renewal, I didn't mean to. I
That's,
meant renewal.
there was no non-renewal, so everyone
Was
keeps,
it an automatic renewal, though? I mean, was
No.
he entitled to have a renewal?
no.
He
No.
had a right to a renewal.
He had a right to renewal under some guaranteed payments, but interestingly, if you go back and look at the policy, you'll see that there's a schedule attached of guaranteed payments of which they could be no higher. Actually, the premium payments in years 11 and forward could be reduced. So,
If you have a right to renew, couldn't you argue there's an implied right to receive notice or some kind of right of
nope,
notice?
nope, it's the obligation you
How
have.
old was Mr. Lovallo when he died?
Mr. Lovallo was 69 and
Therefore, he was not 70, and she told the company she wanted to
To-
insure him
No.
until he was 70.
go back and look at the language. She wanted to pay for the policy. And that is a big distinction here. She never said, I want to renew or I want to insure. She said, I'll pay for the policy until he's 70. That again presupposes that somebody renewed that 10-year term. So we're right back to where we started.
Why isn't that letter an adequate renewal?
It just by its very language, it's not. It says, and I went back and took a look at this right before oral argument, it specifically uses the words pay. I will pay for that policy until the time he's 70. And why that's very interesting to me is she didn't use the word, I want to keep the insurance in effect, I don't want it canceled. All she said is the money's going to come from me as long as this policy is in effect. And I will pay to it
Which I
until
intend
70.
to be until he turns 70.
Until he turns 70.
Counsel,
That's
don't
right.
people usually equate payment with the intent to keep the policy in effect? I don't think that. I think that's a semantical
You know why?
dodge there, unfortunately.
Well, yes, there is, because remember, we've got two different people here. We've got a person who, and I want to also clarify something else. When this automatic account was first started, it was in their name together. We did not know, and the evidence in the record shows we did not know it was just in her name. So we thought we were debiting both of their accounts. It was later changed to just her name. But yes, I mean.
No, but as he pointed out, she wrote you and told you, I am paying.
Your Honor, I agree that she said she would be the one to pay. I agree with you on that.
And would do so until 70.
I'm sorry?
And would do so until he was 70.
She would pay, but that presupposes there's a policy to pay for. And that's our point, is on the 10th.
Is there any reason why, when 10 years earlier when they signed up, that they could they not at that time have given the company a writing saying, we do intend and hereby advise you that we are renewing at the end of this 10-year term?
Could they have done that in advance?
Yes.
I don't know, 10 years ahead? I don't know if there would be any statute of limitations or frauds issues with that, but possibly. I've never looked at that issue before.
So why can't that letter serve that purpose?
Because it doesn't say that. Because it just says,
All right.
just
Let me
says
get
pay.
back. 'Cause
But
Oh, can I have, you go ahead.
I'm sorry.
I want to get back to this. Did he have an absolute right to renew this policy by paying it?
he had the right to renew, yes. If he renewed, he had the right under the premiums set forth after the 10th year.
All right, I want you to suppose that at the end of that policy that you forgot to send any notification to Mr. Lovallo. Would your company be liable to him?
No. No. No.
But he had an absolute right to do it. If he had an absolute right to do it, why wouldn't she have had an absolute right to do it under the equitable ownership theory of that case he presented?
That is my point exactly. If he had the right to do it because he was an owner and she wants to be an owner, then she should have done it. But what she came back and said is that I want the benefits of an equitable maybe and none of the responsibility of renewing the policy.
I think your better argument is that maybe they both had a right to renew, but even if they didn't renew, we weren't required to give notice. Is that your argument?
Yes, Your Honor.
Your time is run. Thank you.
Thank you.